that's what scares me about how that plays out in front of a jury.
We are the Armed Attorneys. Today we're talking about two fairly high-profile carjacking cases that have popped up in the news and kind of the law as it relates to defending yourself in your vehicle. Now, we're going to be talking about Castle Doctrine, how it might affect stand your ground, and what level of force would be legally justified in each of these scenarios. But before we begin, show your support for the Second Amendment by hitting that like button. Now, the first case that I want to discuss came to us from the folks over on Twitter. Love it when you all message us, send us emails, add us on social media, pointing us to these different stories, because this is a great case to illustrate a couple of different things. Now, the brief overview, this was in Inglewood, California. A man was carjacked, tragically losing his life when he was dragged to death. From the news story over at NBC.
A man who became tangled in a seatbelt and dragged to death in Inglewood has now been identified as 63-year-old Larry Walker from La Habra. Police say Walker was killed during a carjacking that turned into a police pursuit Thursday afternoon. Family and friends tell us Walker lived in L.A. for 40 years and ran a group home for mentally disabled youth.
Been dealing with a lot with his health, and never in a million years would I think something like this would happen to him.
What happened to my father out here has torn my family apart.
Now, the second case that came up was in Chicago. Tell us about that one.
Yeah, this one actually really, really terrifies me.
He's hijacking the car. He's hijacking the car right now. Hey, drive off, man! Hey, drive off! Oh my God. He just hijacked that. This motherfucker just hijacked that. I can't believe that. I seen it all.
So we've got this situation in which, I mean, he's just like waiting to walk out in traffic so that he can carjack someone. I mean, it's terrifying because it's like, how do you get away from that? I mean,
Yeah, I've seen a little bit of speculation as to whether they faked a car wreck or was just wandering out in the roadway, but man with ski mask and roadway does not make for a good time.
No, it's chilling to think about. So, I mean, like my first reaction to that, and you know, you probably heard the guy filming say something like, drive away, man. You know, we think about deadly force and we think about self-defense, and we're generally thinking about our firearms or other sort of personal carry self-defense tools. Your vehicle is, yes, a deadly weapon. However, you could use force by hitting someone with your vehicle in the situation where they're coming at you with a ski mask and a gun trying to carjack you, right? So, I mean, that really was the answer. Hit the gas. I mean, he's not, you know, you are probably not going to be shot to death while you are running him over, right?
Yeah, and there's two big factors here in states, and that's whether or not your vehicle is considered an extension of your castle, or, you know, you sometimes refer to this as the Castle Doctrine, and that is we should feel extra layers of security in certain places. That's usually our houses, places of employment, and the third most common is in your vehicle. Now, a handful of states don't have Castle Doctrine inside of your vehicle, and so, you know, what do you say to those folks who find themselves in this situation?
I mean, you just have to rely on, am I being confronted with deadly force? If yes, respond with the reasonable, immediately necessary deadly force. But Castle Doctrine is, of course, much, much better. Also, if you live in one of those states, call your local lawmakers, call your state reps, call your state senators, because it really is outrageous that anyone has to live in a place where your vehicle is not protected by the Castle Doctrine, because the Castle Doctrine does something very special, right? You're no longer establishing that there was, you know, a deadly threat to your life. That's not what you're proving in court. What you're proving in court is that someone violated your castle. So ultimately, it's not this person was going to kill me. That's not the standard of proof. Standard of proof is this person was, you know, whatever the state law says.
Typically a forceful and unlawful entry.
Unlawful and forceful entry, some words to that effect, into the castle. And that's just a way better place to be. And then if you live in wonderful states like Texas and so many others, mostly in the South, frankly, where you are also lended a presumption of reasonableness,
right,
then you really are golden. I mean, you're very well protected. You don't have to worry. Someone tries to break into that vehicle while you're in it. Of course, we're talking about carjackings. You know, you are really safe to defend yourself. I mean, it's just tragic to me that in large swaths of the country, you do have to be wary about defending yourself. I mean, maybe do you just have to get shot and let them take your car?
Yeah, the lawmakers are saying you should have died.
Right.
You know, and so
how important is that car to you?
Right, exactly.
Let it go.
Right.
You know?
But we know that at any point, and that first case illustrates this perfectly. Well, first off, when someone has a firearm, there are clearly always a continuing threat so long as they're within sight line, you know, and you're not behind cover. They're always a threat of deadly force. Now, the act of getting out of your vehicle or being removed from your vehicle, we see that threat continuing in that first tragic case by getting dragged to death. And we all know that a car, especially, you know, when my wife drives, can be considered deadly force. Now, the second issue that comes up, generally, let's say if you're in one of these Castle Doctrine locations, states that have Castle Doctrines generally have no legal duty to retreat imposed on folks when they're inside of their castle. But going to those locations where maybe this is not considered a Castle Doctrine location, what type of argument might be put to a jury in this scenario? Would they say, hey, you should have retreated first? What would that look like?
Yeah, and so this is what's interesting is, first of all, I'll say, if you're ever in like a road rage type scenario, even if you have no legal duty to retreat, we're always going to tell you, hit the gas, get away. You know, I mean, that's a great option. But in this scenario, is the state going to argue that retreat wasn't hitting the gas? Is the state going to argue that retreat is just getting out of the car and giving it up and then maybe getting shot on the side of the road as they get in your vehicle? That's what scares me about how that plays out in front of a jury, is not you should have hit the gas, because I mean, I think that's just general good practice to get away from a scenario. But does retreat mean getting out of the car and giving it up? What do you think?
Yeah, I think it's going to be a combination of the two. And you better believe that there's going to be a shiesty prosecutor who says, hey, you should have got out of the car. You're defending, you know, material possessions. And the context that this comes up in, though, I would imagine is, let's say you or somebody rips open your door and you discharge your firearm right there. Or maybe they make it to the driver's seat and that's when you shoot. Because they're going to say, hey, he was no longer a threat. They're going to drive away. All these other arguments, you should have just retreated. That's a scenario that I imagine comes up probably the most frequently in this context. But it's a really tough scenario. And especially, you know, you got one chance at life, and there's a lot of danger out there, and just the Monday morning quarterbacking and second guessing. That's why those legal presumptions are so important.
Yes. And I mean, pretrial immunity hearings, right?
Yep.
Because that's something, I mean, we don't even have that in Texas here. That's something else, because once you take someone's worst, 1 to 5 minutes of their life, put it in front of a jury and have a, seasoned prosecutor pick that apart millisecond by millisecond, which we've seen in these high profile trials, anything can happen. And we want to do everything we can to stop that process from occurring, whether it be legal presumptions that might convince people not even to bring charges, or whether it be some sort of pretrial immunity hearing where the state really has to prove it in front of a judge before you can go before a jury, because a jury of your peers is just, a wild animal.
Yeah, but in this second scenario, man with ski mask on roadway with firearm, I think that a use of deadly force, most juries would say that's probably going to be reasonable.
I would think so.
But we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us find the anti-2A algorithm by sharing this video.
And as always, leave a question, give us a comment. Until next time, we're the Armed Attorneys.